Um, okay, so what do companies do? They do a few things. They adopt rules to flesh out their terms of service. I think this is a class full of people, or an audience, let's say, people. I don't have to tell you what terms of service are, but of course, you know, when you sign up to join any service, you're also accepting their terms of service. All of the companies, and I know that, I think you read Kate Klonick's piece maybe a few weeks ago, you know, all of the companies have community guidelines or rules, community standards that that basically explain what it is you can and cannot post and share and so forth on the platform. They have, you know, what Facebook has called, in order to actually flesh out their terms of service, they have mini legislatures, basically, in which they make what I think of as platform law. I mean, they are basically making the rules for what we can and cannot post online. And they're doing it in a way that I think is, and has become, highly bureaucratic. You know, 5-10 years ago, I think it would have been safe to say that many of the companies, even when they were trying to do the right thing, were generally dealing with content sort of as it happened. Like, as the controversy developed, they would make up a rule for it, or decide, you know, what are the values of the company, and they would deal with the particular content in that way. All of them, you know, with some distinctions in terms of how bureaucratized they actually are, all of them have moved away from a kind of seat of the pants approach, and they do this kind of work. They adopt their rules and they enforce them in a highly articulated manner. And then, of course, there's tens of thousands of moderators. These are individuals who are actually working on you know, all of the suspect content. And there are many ways that content can get to a moderator, or to an agent, as many of the platforms call them. There are thousands of individuals who are basically deciding what is consistent with the rules in any given circumstance and what is inconsistent with the rules. We're in this very interesting moment right now where probably many or all of you know this, but, you know, because of coronavirus, many of these moderators who work in, you know, basically in call centers around the world, you know, most of them have been sent home, you know, for good reason of physical distancing. But that means that the companies are putting even more pressure on their automation, you know, on their AI, on, you know, different forms of automation that they have, in order to implement their rules in this automated way. So automation is a natural part of content moderation today. I mean, as companies are doing moderation, when you think about the amount of content that we're talking about, I think Facebook's, at least in 2018, the figure that that they gave to Congress was, I think, 400 hours, maybe 500 hours per minute of video uploaded, which is, I mean, really kind of unfathomable, which is also, I guess, unsayable. But that's an enormous amount of content. And that's not the kind of content, even if a very slim percentage of that content raises concerns under their rules, they're still going to need automation in order to determine, you know, which of that content should be seen by a moderator. Occasionally, and now this is happening more and more because there are fewer moderators actually working, which content should just come down as a matter of course, without even that human in the loop to review that. So let me say a little bit more about companies. First, on the content moderation, on their mini legislative forums. This is actually, I mean, I think it kind of looks like a highly staged, but I think this is a real mini legislative forum. The head of content policy, Monica Bickert, is there in the bottom right corner, and her team is there at the table. You know, this is a group of people who are looking at very specific kinds of rule changes. And I sat in on one of these mini legislative forums. I think they're like Tuesday morning, and for an hour, they go back and forth over a particular rule. Is this rule the right one? Does it match our brand? I mean, they don't use the word brand, but does it match their standards and their values as a company? They're constantly doing that. They do this, I think, on a bi-weekly basis, although right now with with most people not working at home, I'm not sure exactly how they're doing it, but they are acting in all senses, I think, like a mini legislature. Twitter doesn't have the same exact kind of, I would say, bureaucratic organization, but they also have their rules, just as Facebook has its community guidelines. YouTube, same thing. And you can go, all you have to do is do a search for YouTube and community guidelines, and you'll be taken to the pages where you can learn exactly what they're doing. These are updated pretty regularly. I've done this, I think most times I visit a page, I archive it at the Wayback Machine, because it's really interesting to go back even over months and see how they do little tweaks to their rules over time. Now, one of the interesting things that you see here in YouTube's rules is if you look at hateful content, they say there, our products are platforms for free expression. They're aligning themselves with a kind of ideal of, we're a platform that supports our users and their ability to share content. But then they say that we don't support content that promotes or condones violence, and it goes on. These are all, pretty good rules. They don't really tell you where they come from. I mean, and this is where we'll get a little bit later. I mean, basically, these are rules that, and this is true for all the companies, these are rules that they have decided are the right thing for their users, are the right thing for their brand. But one of the interesting things over the last, I would say, 3 or 4 years, especially the last 3 years, despite the fact that all of the companies that are in the space of user-generated content, they all say they're doing something different. YouTube will say we're not social. Facebook will say we're not search. You can do a lot of the same things on all the platforms. Their rules have been largely converging. There may be differences around things, and maybe we'll talk a little bit about things like political advertising. But generally speaking, on core issues, their rules have been converging around things like this, as you see with YouTube. The guiding principle being free expression, but we do have restrictions around promoting or condoning violence. Now, one of the problems around the rules, at least from my perspective, is that they're very often drafted and presented to the users in very generic ways. So, like, what does it actually mean for YouTube to say we don't support content that, quote, promotes or condones violence against individuals? What does the promotion of violence against groups, what does it mean to be based on race or ethnic origin? Look, I'm a lawyer, so I could find sort of some uncertainties in this language. I think we can all understand generally where this is heading and what the meaning is here and what their intention is, but how any particular content is decided as to whether it's consistent or not with these rules is really quite opaque. There's not a lot of, there's nothing like a kind of case law around company decisions so that we can understand exactly how these different terms are understood. Anyway, there's more on hateful content policy, hateful conduct, and we can talk a little bit more about that maybe in the Q&A. But you can see through all of these rules that they've, particularly if you were to go back and compare them to the rules that they had in place 5 years ago, even 3 years ago, probably even 2 years ago, you'll see that these rules have become, more, I'd say, denser and denser in terms of what they're trying to deal with and to protect. Okay, so that's what the companies are doing. I mean, that's really in broad, a kind of broad brush approach to what the companies are doing. But the companies are very much, and I would say this is because of public pressure and because of their sense of brand, they've moved very much in the direction of thicker and thicker rules around around what people are permitted to post and to share. Okay, so if companies are moderating, governments are regulating. And just to be a little bit clear about what I mean there is, you know, internet chat boards 20 years ago, bulletin boards, chat rooms, etc., all the way up to today, they've always had a function of somebody moderating. I mean, not all bulletin boards had a moderator, but it's always been a part of the sharing culture. And you see this especially in the context of Reddit, I would say, where you have the community moderating itself in a way. There's always been moderation, and that's always been the term, or largely that's been the term that's been used among platforms and other parts of internet sharing. Governments, though, have always, they're not in the business of moderation. They're in the business of regulation, and they can do it in multiple ways. They can do it by focusing on the companies themselves, that is, who's hosting the content, or they can focus it on the users. Now, it's obviously a little bit more difficult for governments to regulate users directly when the companies have strong policies of, say, anonymity, or even strong versions of pseudonymity that make it difficult for government to identify a particular user, or in the context of say a defamation suit, for a person to identify who has defamed them. That can always be a problem. So there's been a very heavy focus over the last several years on government regulation of the platforms rather than particularly on users. But I'll talk about both over the next few minutes. So what are we seeing? We're seeing governments pushing back, and they're pushing back with direct demands against the companies. So let's say we're talking about Twitter in Turkey, and there's a terrorist attack. Very often you will see the government demand that Twitter take down content, and they'll do so either through legal channels, that is maybe through their courts, or they'll do it through what I call extra legal channels, which is a government minister picking up the phone and calling somebody at Twitter if they can find their number. We see company codes of conduct. By that I mean governments are pushing for industry-wide codes of conduct, whereby, and this is particularly true in the European context, where they're pushing for the largest companies to agree to codes by which they agree, we will take down hate speech, we will take down speech that is inconsistent with your laws, and it's done in a voluntary way. So there's pressure behind it, the pressure being, if you don't do this voluntarily, we're going to regulate you. But we do see a lot of codes of conduct. We also see, I mean, outside of the democratic framework, we see a lot of criminalization of users and platforms. By this, I mean, we've seen instances increasing where governments are saying to companies, if you don't meet our standards, if you don't moderate content according to our own law, then you're going to suffer penalty. Oftentimes that's civil penalty, but we've seen many cases. For example, in Brazil a few years ago, we saw a situation where a Brazilian judge actually ordered the detention of a Facebook executive in Brazil because WhatsApp was not sharing user data with the judge. So we do see a kind of intensity around government approach to companies and to the platforms. And then we see civil liability for harmful content. And I'll try to cover each or many of these different areas over the next couple minutes. Now, it may be that you've already talked a little bit about Section 230. Yeah, maybe a little.
A little bit, but we have Marianne Franks giving a guest lecture on that on the 20th.
Excellent. All right, so I don't want to get too deep into Section 230 anyway, but I did want to give just an overview to give a sense of what sort of the spectrum that's available out there. Under Section 230, essentially, and leaving the details to the next couple of weeks for you, under Section 230, companies are not liable for the content that users post on their platforms, or I should say, and they're not liable for any of the rules that they, generally speaking, for any of the rules that they implement related to the taking down of content. In other words, Section 230 allows the companies to decide what their rules can be, what they can leave up, and what they can take down. Now, on the margins, that isn't totally true. So around issues like child sexual exploitation or sex trafficking, which has developed over the last couple of years as a particular focus in online content, there are specific rules that impose requirements on the companies. This is also true of some terrorist content. And there are mechanisms that the companies have developed. But generally speaking, in the United States, the companies are not liable for the content that they're hosting. This is also true in the European Union, although there's a slightly different valence to the way the rules are framed in Europe. Basically, in the United States and Europe, there's no obligation on the companies to do any kind of regular monitoring of the content on their platform to determine whether it is lawful or not. In the European context, there's essentially something like a notice and takedown requirement, such that when a platform is notified of illegal content on the platform, they're under an obligation to do the due diligence to ensure that it's taken down, or if it's not illegal, to not to take action. But that is more of a notice and takedown process that is actually quite familiar to US intellectual property lawyers when it comes to online content. Okay, so that's one set of, or one way of thinking about what governments are doing. And I'll get into others over the next few minutes. Another way in which governments are putting pressure on companies is through things like the EU Internet Referral Unit. This is a unit that does not operate according to a set of legal rules, such that they must go to a court, get an order, and then say to Facebook, take this content down. What the EU Internet Referral Unit does is basically scour the internet or take reports from individuals across Europe about content that might be terrorist content, quote unquote, extremist content, other kinds of illegal content, that then the EU, this IRU, which actually there are IRUs across Europe in different national settings, they will then bring that to the attention of the companies and essentially ask that they take it down. But those asks are not legal asks. They're not making their demands, and I think the companies feel them, to the extent a company can feel, they feel them as demands, but these are not coming through as legal orders. We do have another way in which the companies get demands for takedowns. We have legal requests. So oftentimes, as opposed to like an IRU, which will, again, pick up the phone, send a letter, send an email to some general account at Twitter, legal requests are requests that come through typically the courts of a country, or through some other regular legal process in which they say, you need to take this down because it violates X rule. And you can see actually many of the companies over the last several years, in fact, all of the American companies, at least the biggest ones, do transparency reporting in which they indicate where they have received legal requests for takedowns from. You can also get many of these at Lumen, Lumen, lumen.org or .com, I'm not sure. And you can actually see the nature of some of these specific takedowns or takedown requests. Okay, so that gives you a sense of what governments are doing, maybe at a sort of big picture level. We also see governments specifically identifying the kind of content that they think should be taken down. So Australia last year, it was actually within days of the attack in Christchurch, they adopted this law. It was sort of proposed on a Tuesday and enacted on a Thursday. I think quite literally, Australia adopted this law that prohibits the sharing of what they called abhorrent violent material. And this is material particularly focused on live streaming, where the government was saying, look, you can't share that kind of material any longer. And if you do, there will be severe penalties on the company for allowing that to be shared. In Germany, this is perhaps the most prominent of national laws that have been adopted over the last several years. Germany adopted this law, which is completely unpronounceable to me in its full German. So thank God they just call it NetzDG. NetzDG, the Network Enforcement Act, is a law that basically requires any of the large companies, and it specifies what they mean by large companies. It requires any of the large companies to take down content that is illegal under German law. And it specifies the specific laws that they have in mind. Most of them are around issues like Nazi paraphernalia, Nazi messages, hate speech, really incitement to violence. But there's also laws around criminal insult, which is a law in Germany. And basically they're asking the big companies, mainly Facebook, Twitter, and YouTube, to take down the content that is illegal under German law. Now, the concern there, and this is a concern I'll come to in a little bit, because we see it everywhere, is that the government is essentially saying to the company, you need to evaluate what is legal and what is illegal under our law. This doesn't require a court, for example, to assess whether any given content is or is not illegal. It's up to the company to make that determination. My own view is that one of the problems with that is, of course, the companies are going to be eager to avoid liability under NetzDG. And so they're likely to take the view that, where there's any question, they're going to take down the content. In other words, it encourages the takedown of content that may even be perfectly legal. Singapore, and I think this should be the last law that I'll talk about, just at least from the last couple of years. Singapore adopted a law last year that's called the Protection from Online Falsehoods. In the law, they talk about it as deliberate online falsehoods. It's basically an anti-fake news law that gives power to any minister in Singapore to order a platform, a broadcaster, a media outlet to take down content if it's deemed to be false. Again, it doesn't go through a judicial process, and that's of course deeply problematic from the rule of law perspective. There are other areas that we could talk about as well. Famously, the European Court of Justice in 2014 adopted what's known as the right to be forgotten as a rule of law. Basically says that companies, and they were focused in particular on Google, companies need to make available to anybody within Europe a process by which that person can seek the deletion of a link, the delinking of a URL, so that, for example, if an individual does a search, a name-based search of someone, and that person thinks that that information is no longer relevant or somehow interferes with her privacy, that person can have that link removed. In fact, if you look at what they actually say, it's kind of interesting, because Google says, we will balance the privacy rights of the individual with the public's interest to know and the right to distribute information, which is kind of interesting because Google's just a company. I mean, it's not the government deciding what's in the public's interest. And not only that, it's an American company making this decision. Tens of thousands of these requests are made every year through a form that Google makes available. And anyway, it's a part of the overall process, which, you know, may be legitimate and may not, but it's the overall process of governments pushing back against companies, against company content moderation. Okay, so hopefully that's laid out like the overall setting of company moderation and government regulation. I want to spend a little bit of time now talking about users, because like in all of that, I mean, where are we? I mean, we obviously have tools, as I mentioned here, you know, to flag content that we object to report it to the company and so forth. But what are the standards? You know, one of the things that you see in all of those rules, I should say one of the things that you don't see in any of those rules is like, what is the source of the rule? Is the rule just coming up because, you know, the company decides this is in our best interests as a government, as a company? Are the governments deciding, you know, we think these rules are important just because, you know, this is how we see freedom of expression, freedom of speech, privacy in our own country? Like, what should be the basis for these rules? I would say that, you know, the default setting normally, I would say this as an international lawyer, is that, you know, the rule depends on the jurisdiction where you are, right? Like if I'm in Germany, my freedom of speech depends on, certainly on human rights law, but it also depends on the rules in the jurisdiction. The same is true in the United States. The rules around the First Amendment are, you know, exceptional. I think for many Americans, it's a part of our DNA to think of the First Amendment and freedom of speech as being a deep part of our political, economic, social culture. But, you know, the internet makes this a little bit uncertain, right? Because we're talking about companies that are global, right? They're companies that are adopting community standards. You know, it's funny because, you know, Mark Zuckerberg has talked forever, I think a little bit less so now, about, you know, the community. And the community isn't one limited by, you know, by national jurisdiction. And so when you have companies that are so spread out, that are in a certain sort of way jurisdiction free, what rules should apply, right? You know, when should it be that the companies simply have different rules for every country they operate in, or should it be that they have a set of rules that apply everywhere? And so I want to talk a little bit about that. I guess I asked some questions. I forgot about these. These are the questions I'm interested in. How should individual rights be protected? How should people and communities be protected, particularly if we're talking about something like hate speech? And what law should govern online speech? Should be law or company policies in terms of service? So just to give you a little bit of background, so the UN appointed me as they call it special rapporteur. If you can ever get a job, even temporarily, where you're called special, I highly recommend it. But anyway, it's special rapporteur means basically that I monitor freedom of expression around the world and report to the UN on these issues. And I've been reporting, my last report to the Human Rights Council last year was on the private surveillance industry. So things like NSO Group out of Israel, sort of the increasing surveillance of individuals, you know, through our mobile phones and elsewhere. That's obviously going to be something at issue in in the current pandemic as well. But basically, I monitor, and there are 50 or so other special rapporteurs who monitor other areas of human rights law. I work closely with the UN's Office of the High Commissioner for Human Rights. And here's the law that, I mean, here's now we're finally getting to some law. Here's the law that's really relevant, in my view, to thinking about the companies and thinking about users. So the fundamental kind of central treaty in human rights law, there's actually two. One is called the International Covenant on Civil and Political Rights. The other is the International Covenant on Economic, Social, and Cultural Rights. Those two covenants basically form, together with the Universal Declaration of Human Rights, what some people talk about as the International Bill of Rights. In any event, the ICCPR, which is the Civil and Political Rights Covenant, its Article 19 provides sort of the basic foundational rules for freedom of expression as a matter of human rights law. And I've just sort of shown it here as a slide. It's actually quite a robust right. And if you want to think about it as a comparison to American law, that's actually useful, right? So if you think about the First Amendment says Congress shall make no law abridging freedom of speech or of the press, right? So it's very much focused on what is the limitation on the American government. We get there in Article 19, but to me, what's interesting is how Article 19 is puts the individual at the center, right? I mean, it says everyone shall have the right to freedom of expression, and it says what that right is. It's the right to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, and through any media. I actually think that's a really robust statement of freedom of expression. It's multi-directional, right? It's what I can seek and receive, right? It's also what I can impart. It's regardless of frontiers. So there's a debate. I don't know if there are any students of human rights law who are in the class. There's been a debate over decades, really, as to whether human rights law, that the obligations of one state extend beyond its jurisdiction. Well, it's to a certain extent academic debate, but here you see the freedom of expression actually applies across borders. I have the right to seek information across boundaries here, and it's through any media. To a real extent, Article 19, paragraph 2 is a freedom of expression for the internet age, right? Seeking and receiving is kind of browsing, downloading, etc. Imparting is sharing, posting, etc. It's really quite robust. Then you go down to paragraph 3, which says that the rights in paragraph 2, and this is to be distinguished from paragraph 1. Paragraph 1 says everyone shall have the right to hold opinions without interference. That is not subject to any restriction. But paragraph 3 says that the right to freedom of expression may be subject to restriction, but it's a pretty narrow set of restrictions. Those restrictions must meet 3, and this is cumulative, 3 conditions. They must be provided by law. By provided by law, basically we mean, and this has been interpreted over the course of decades by human rights mechanisms, human rights bodies, provided by law basically means it's a law that's been adopted through a normal legal process. So it's not, just an emergency legislation kind of thing. It's been adopted normally. But I think more importantly, because it's easy to adopt a law. I mean, unless you're the US Congress, it's easy to adopt a law. Basically, it means our law is not vague. It's not so broadly drafted that executive authorities, the police, security services, et cetera, have broad discretion to decide what is and is not subject to regulation. So that's one condition provided by law. The second is necessity. By necessity, we mean it can't just be that a state is adopting law that is, it's useful, it'd be helpful. it actually has to be necessary. And we understand necessity to include the idea of proportionality. So if you adopt a law to address, for example, national security, the expectation is that the state will demonstrate that its restriction is not only necessary to meet that, that need, but it's also proportionate, so it doesn't interfere with other rights that individuals might have. So you have provided by law, you have necessity and proportionality, and then you have the legitimacy of the objective. So it means that a state can restrict freedom of expression where it meets one of these legitimate goals, the rights or reputations of others. So you could think of the right to privacy, for example, for protection of national security or public order. Unfortunately, states over the last several years have been deciding that everything is national security. And so they've been making claims to restrict all sorts of expression simply by saying, well, it's a matter of national security. So it's deeply problematic. I don't want to give the impression that I think paragraph 3 is kind of a perfect set of constraints that always works. I mean, much of what we do in advocacy and in scholarship is try to narrow these responsibly. Governments obviously want to move in a different direction. And finally, another set of legitimate objectives are public health or morals. Now, morals, I'm going to park to the side. Unfortunately, it's one of those areas where governments that want to restrict expression use that and think they can drive a truck through that exception, essentially. Public health is particularly interesting right now. Again, we can talk a little bit about that. In the context of the coronavirus, clearly there will be efforts to restrict expression, maybe on grounds that we don't want to create, government doesn't want to create a public health panic, for example, or we don't want individuals to be sharing the kind of disinformation that actually gets people killed. Like the president, promotes certain kinds of drugs. I mean, there's all sorts of issues around that, but this is basically the framework in international human rights law that we tend to use in order to understand whether any given law is legitimate or not as a matter of freedom of expression. And I guess I underlined those too. Now, for purposes of hate speech, there's also another article, and this is Article 20. Now, actually, hate speech as a term is not a term of art as a matter of international law. I mean, there's no rule, certainly not in the ICCPR, that says hate speech is prohibited. Instead, this is the closest thing that you get to it. And it says, any advocacy of national, racial, or religious hatred. So there's your hatred part, and it's limited to national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited. Now, this is, frankly, a bit of a problematic provision of human rights law. The United States actually declared a reservation to this. It doesn't consider itself bound by this. I think mainly because the idea of incitement to discrimination or hostility is seen as very problematic under the First Amendment. But the idea of incitement to violence and hatred that constitutes incitement to violence is something that's broadly accepted by states around the world. And it's often this provision that is used as the tool for dealing with hate speech, if we can call it loosely, hate speech around the world. Okay, so before I get to company responsibilities, let me just say that as a matter of international law, Article 19, Article 20, there's also Article 17, which protects the right to privacy. These are standards that were developed by states, they were adopted by states, they were ratified by states, and they only obligate states, right? Only states are obligated under international human rights law. It doesn't impose on its own any obligations on the companies. So what we need to do, and let me make another point before I move on to the companies, which is, in my view, the human rights law that I've identified here, and I have to emphasize, this is sort of the high level general law. There's a lot of law that specifies the meaning of all of these different terms. But my view is that because the companies are global, because their jurisdiction is so broad, it's human rights law that's focused on individual rights and individual users. If we want to think of individuals as users, it's this law that really can shape what those rules of the companies should be. And we could talk a little bit about why that is in a little bit. But since that law only applies, at least strictly speaking, to governments, there is this open question about what should be the role of companies in a world like this. I mean, the companies clearly have massive impact on public discourse, on the sort of the dissemination of hateful content, on the incitement to violence that is taking place offline. The companies have a very, very significant role in the information ecosystem today. And several years ago, actually not just in the context of digital rights issues, but in the general context of multinational companies having enormous power in all sorts of spheres, the UN adopted what are known as the UN Guiding Principles on Business and Human Rights. Sometimes you'll refer to them as the Ruggie Principles, named after John Ruggie, who he's a political scientist now at Harvard. He was at Columbia, who basically helped develop these rules through a very robust process of engagement with stakeholders around the world. And the UN Guiding Principles basically have three pillars. The first is the pillar of protect. That's what governments are responsible to do. Like, governments have the obligation to protect individuals and their human rights. But companies, he said, and the guiding principles provide, have an obligation to respect those rights. This is actually where the framing of human rights law is actually useful. Because remember, if you look back at human rights law, if I go back to Article 19, remember, it's focused on the individual. It's not just focused on government or a public authority's restrictions. It's also focused on the individual's rights. And so if you look at and you think about that middle part of respect, what the UN Guiding Principles say, and they were adopted by the UN Human Rights Council, which is the central human rights body of the UN. It's a part of the General Assembly. What they basically say is companies that have an impact on human rights need to do due diligence in order to ensure that they mitigate that impact. And so, so that can mean a number of different things. And what you see in the UN Guiding Principles are basically calls for companies to be transparent about their rules, to be adopting human rights policies, so that when they have rules, say for instance, around social media, so that they adopt rules that are respecting or respectful of individual rights to freedom of expression. And that can go especially to things like hate speech, where the offline impact of particular content can be particularly harmful. They include those kinds of calls for companies to essentially observe the rights of individuals. And then finally, the third pillar is remedy. And they basically say, look, if you do violate the human rights of individuals, you need to have a mechanism for remedy. So over the course of the last several years, both in my own context as special rapporteur, in the context of the Human Rights Council and the General Assembly adopting resolutions that highlight what they think international law should be around this space, international law has increasingly moved in the direction of saying a couple things. One is offline rights apply online. It's been something of a mantra over the last several years. And at this point, it seems, quite obvious, probably to all of us, it might seem obvious, but it wasn't 5 years ago when the Human Rights Council started saying this. And part of my role with the UN has been, I think, at least the way I've seen it, has been an effort to figure out, like, what does that actually mean? Are there ways in which online space is different from offline space, such that the rules should apply differently? We also see that we do this work in the context not only of reporting, and we see from resolutions. I engage directly with companies, with countries, and with companies all the time to encourage them to meet their obligations or responsibilities to be mindful of the rights of individuals. So now I'm getting to the point where I'll kind of wrap up here. What does a human rights approach to online speech look like? Now, I think certainly on the private and tech side, the private companies, mainly we're talking about social media and search, but it can be others also that have a role on content. My view is they should be moving their content rules to be more aligned with human rights norms. Those rules should protect individual users' rights, right? They should be focused on that. They should be doing due diligence to ensure that the rules that they have are consistent with user rights. They should be focused on things that are fundamental to human rights law. For example, promoting user autonomy, user control, and user education. They should be transparent. Right now, there's a certain level of transparency by which you can go to their community guidelines and you can see where where their rules sit when it comes to hate speech, harassment, disinformation, etc. But we have very limited insight into how those rules are actually implemented. And we need to have more transparency around them in order to understand how those rules work. That is one way to think about that. Is if you go back to looking at Article 19 and the provided by law standard that I mentioned, it's basically saying that standard of having clarity in the rules should apply not only to governments, but to these companies that have massive power over speech. I think there should be multi-stakeholder engagement. By multi-stakeholder, I know that sounds like a bit of a wonky term. When we think about public participation in government, right? The right to vote, the right to make your voice heard. The same is true, or should be true, for these super dominant companies. Stakeholders, that means users, activists, activist groups, communities, need to have more of a role in engaging with the companies in order to help them understand how their rules can best protect individual rights. So that's on the private and technology side. Then there's the state and regulatory side. One is, I still think, even though the move around the world is to impose a liability on intermediaries, my view from experience and from seeing how intermediary liability rules work, that is, when I say intermediary liabilities, that's like Section 230, rules that are designed to impose liability on the companies for the speech of those they're hosting, speech of their users. My view is, having seen how these operate, is that intermediary liability tends to work in a way that it restricts freedom of expression and doesn't so much protect individuals against the alleged harms that we might see online. States should, promote a legal environment for freedom of expression. I think that means a number of things, but it certainly means that when it comes to dealing with online content, basically the rule of law should be the standard, and it shouldn't be available to states simply to allow a minister to say to a company, take down particular content. That means independent judiciaries should be essential in the way we think about the relationship between governments, public law, and the private platforms. One of the things that I think governments have really missed out on over the last several years is that while they've told companies, you need to evaluate content according to our law, they haven't created any kind of independent structure that is accountability driven to allow, they're either independent authorities within their government or independent judiciary to make those kind of evaluations. And much as there should be transparency by the companies, there needs to be much better transparency by governments as to what it is they're actually asking of the companies. So I think that's it. I just end with a very dark screen, which seems ominous. Maybe I'll just leave this up for the time being.
Yeah, thank you, David, for that. Under normal, non-virtual, non-pandemic circumstances, I think there'd be an applause right now, but I think I speak for everybody in saying that that was really informative. I'm not a lawyer, nor do I play one on TV, but doubly so for me. So we're going to transition into like this Q&A format for the remainder of the class. What I'd like everybody to do is to just add your questions in the chat. So first I'll ask a few questions of David, and then we'll move to the class questions. So we'll just call on you, and you can just turn on your mic, turn on your camera, and ask David whatever question you have. So David, your book, Speech Police, was released in 2019, and it's been an entire year since it was published. And there have been a few significant changes in the online hate ecosystem. So, for example, YouTube now has a supremacist policy to prevent white supremacists from kind of leveraging the platform for their use. But I want to speak about coronavirus. So the novel coronavirus COVID-19 spread aggressively, and it's forcing a large portion of the global population to work from home in a digital environment. Content moderators at some of the largest social media platforms are no longer reviewing content. In fact, I had a call with Facebook last week with their policy team, and they told me that other than a very small team that's just going to be moderating for imminent harm content, all other content will be moderated by artificial intelligence, which to me is a little concerning because I don't think AI is at that point where it can truly understand the context of a lot of hate speech and harassing speech. So I'm wondering, like, how do you see the next few months playing out? Do you expect governments to be more or less reactive to increase toxicity on these platforms? Do you think social media platforms are doing enough?
Yeah, that's a great question. So I think it's a little bit early to say whether the companies are doing enough, but I do think, so first off, I would say that I totally agree with you that the move to pretty significant degree of automation is deeply problematic. I mean, we've known for many years, even as AI tools have improved, they're terrible at natural language processing. And so, that's certainly true in the case of hate speech, where, oftentimes, and you know this better than I do, there's a lot of examples of people either, in a kind of community way, using derogatory terms of their own community with each other, and those terms sometimes become terms of endearment or something else. Or we see that people calling out hate speech are often through AI tools. They're the ones who are caught up in those restrictions, and that's a problem because that creates an environment where even when people are trying to identify hateful content, they're unable to do so because that can be taken down. And if you don't have the human in that loop, if you don't have a human moderator doing that work, clearly more mistakes will be made. And I think it was the first post that I saw that Facebook made on this. They admitted there's going to be a lot of mistakes here. But I think in the context of hate speech and in the context of coronavirus, this is really problematic because, to the extent that people will be sharing information that is, important for people to know in order to protect themselves, I think there's a real risk that, that content will be removed. And I would say that it's worse than that, than it even sounds, because like we might be able to live with that if we have an environment of human moderators around that can manage appeals. But if you don't even have those individuals working to manage a kind of appellate process, so my content about coronavirus and its spread or whatever it might be, it's taken down, but maybe it's important for that information to be out in my community. Who do I appeal to when that takedown actually happens? I mean, so I think that it will be really problematic. Now, that's a different question than like whether their rules themselves are good on this. I think the early evidence seems to be that most of the big companies are relying, in order to make disinformation evaluations, they're relying on the CDC, which is fine for the United States. CDC is not the global standard. It's really the WHO is the global standard for for information around coronavirus. I would probably prefer if they use that as their standard. But I still think we're going to be, because of the nature of the platforms and the nature of their reach, there's no other choice right now than for them to be in this kind of moderating position where they're going to be deciding, what is legitimate content and what's not. And again, going back to the automation part, with automation, it's going to make it much harder for us to engage with the companies on those particular rules.
Thanks. It's really troubling. You're completely right. And I've been thinking about why they might not want to expand the scope of the people that are working from home, the content reviewers. And there are probably some privacy considerations at play, which is why they don't want to expose a risk to privacy. But I still think that they should probably focus on work from home content reviewers and expand that team.
I agree with that. By the way. I mean, one of the things that this really highlights is just how central and powerful the companies have become and how reliant they've become on the machine-human interaction. And when you take out the human, I mean, I agree with you. I think they really do need to find a way to deal with those privacy concerns because this is really, and it was always this way with hate speech and incitement to violence, but this is really a matter of, of life and death and getting good information out there. It's whether they wanted it or not, that's their responsibility right now.
That's like a perfect segue to my second question, which is about like how powerful social media platforms are right now. So governments often create rules at the margins of speech, outlining extreme speech like incitement to violence and glorification of terrorism. But like troubling speech like hate speech is often, but not always, left to social media platforms. And these platforms create one set of policies that applies to a global market. So it's a one-to-many relationship. Is this an optimal approach? Is there an alternative to that?
A kind of alternative to the super dominance that we've got right now.
Yeah, with governments deferring. I mean, even Europe, you have governments that defer almost completely to social media platforms because they don't want to rules. It might be unconstitutional or something.
I mean, I think that that by and large, governments, they got interested late, which sounds a lot like coronavirus in a way. They got interested quite late in terms of how it is that they can be engaged in ensuring that public rules, public norms apply even on their platforms when we're talking about content in their own jurisdiction. And so, it isn't totally governments or politicians' fault. I mean, the companies exploded out of nowhere in many respects. I mean, when you think about the companies being, born in like 2006, 2007, 2008, it's remarkable how new this all is, and government doesn't typically respond that quickly. But even so, I think that what government was, around the world to a large extent, and answering the wrong questions. They were answering questions around specific content and whether it should or should not be online or be on a platform, when they should have really been asking broader questions about how is it that normal public rules apply in this space. And if we want normal rules around And by normal rules, I mean, rule of law in a country. If we want our rules around freedom of expression, which, most governments, even if they don't have the First Amendment, certainly most governments in Europe, with a couple of sad emerging exceptions like Hungary and Poland, most governments have pretty robust protection of freedom of expression. They could have been thinking about how can we apply that through things like, I don't know, internet courts or independent agencies dealing with complaints. They should have been thinking about that early on. And then as the companies were expanding, as their user bases were exploding, they could have, integrated that thinking into the development of the companies and their growth. But they didn't do that. And so now they're in a position where, when they say, we're asking the companies to make these calls, at the end of the day, what they're really suggesting is these are calls that we can't make. And we believe that the power these big companies have, they have enough resources, they can make the call themselves. And that's unaccountable from a, kind of a public law perspective. And it also locks in the power of the big companies, because only the biggest companies can afford to do the content moderation that now governments are requiring platforms to do. So as soon as a company gets big enough, and meets that threshold under the German law, for example, they're suddenly going to have a huge burden of lawyering in order to decide what's legal and what's not. So, it's problematic all the way around.
It also locks in the power of big countries in terms of like the United States having such a large influence with social media platforms. Kaye Klonek's paper does a great job of explaining like the American origin of the American perspective on free speech in social media platforms, and how a lot of the lawyers that work for these platforms have come from American law schools and they have that training. So in your book, you quote a European official who says something I thought was profound. He says, the politics regarding the internet today is a general societal politics. The question isn't what's best for the internet. Poor and rich, left and right, they are more important than what's good for the internet. And the American model enshrined in Section 230 is focused on kind of what's best for the internet with a good Samaritan component to it. So how's this argument playing out in other countries? Do the needs of private technology companies come before societal needs? And can we even separate the two needs anymore, just given how close the online and real world have become?
Yeah, so Europeans especially, and by Europeans, I mean European officials, people in Brussels, people in different capitals. In the past, I would have included the UK, but I guess they're not European anymore. I mean, basically, Europeans are alienated from the big companies in very significant ways. And their general attitude, their general feeling is that here you've got this big American or set of American companies. They're based in Menlo Park, San Bruno, San Francisco. They're making all of these decisions, adopting all of these rules that have an impact on our democracies, and we don't have a say in it. And I mean, I can't tell you how many, different European officials have said to me that, look, our counterparts in the United States, let's say you're a cop in Wisconsin, that person calls up somebody in Menlo Park to tell them about some problem they have, they're probably going to get their call answered. But when we call from Dusseldorf, that call is not necessarily going through. We're not getting the kind of responsiveness. Now, I mean, some of the companies do have European offices, but the general point that I hear is a lack of responsiveness. But it does go beyond responsiveness. It goes to this kind of core idea that many Europeans feel that they've lost control of their public space. And that is, so, when Europeans, who I quote in the book, when they say that, I do think it's profound. And there's, right now we're in a different moment. And so, European leaders aren't really thinking about this right now. But I think when we get back to normal life, I think this is really a top agenda item for many. And the European Commission is considering a new digital services set of rules that will have an impact here, and it really might have a pretty profound impact if they're ever able to meet again in person. It may have a very profound impact on exactly that question. You know, should our rules be good for the internet, or should those rules be good for society? Now, my own view is those two things are interlinked today. I mean, we shouldn't really separate those out so much anymore. But if you're European and you see American companies moderating that space, you know, you just have a different perspective.
Yeah, and I thought there was this one part in your book where you talk about how attempts at regulation have paradoxically increased corporate power, American corporate power especially, as decisions of content removal are overwhelmingly left to platforms with little guidance on what to remove. So I'm wondering, like, which countries have made the biggest strides in formulating an informed approach of balancing the power? I mean, we've seen the European model, the American model. I'm wondering if there's something happening in Asia or Africa that might be able to address this balance of power problem.
Yeah, you know, the truth of the matter is that the most kind of the most robust thinking around this, I feel like I've used the word robust a couple of times, but the most robust thinking around this around the world has been in Europe. And the truth is that many other jurisdictions around the world look to the Europeans for their model. You know, whether by kind of culture, because maybe they're former colonial or something like that, and they have kind of a network of, you know, of laws that go back decades, if not centuries, or for other reasons. There's a lot of learning that goes from Europe to the rest of the world. And I would say that that if you look at some of the, you know, the most forward-thinking, I mean, much of it has been in Germany. So NetzDG, which is problematic as a tool for governing the platforms, nonetheless, it is a pretty rigorous approach to taking back some national control over that public space. May not be the right approach, but it is an approach, and it's democratic too. At the level of, you know, it was adopted through democratic process. It's not democratic in its implementation because it outsources to the companies making these decisions, but it is a pretty established way of, by established, I don't mean long established, I mean it's rooted in a theory of how the internet should be governed. I think we're going to see more rules like that. I mean, what Singapore did in its online falsehoods law. Now, Singapore is not a bastion of, you know, it's not like a free speech nirvana in the first place. But, you know, they've adopted a lot of the kind of underlying theory of NetzDG for their own rules. We see that in Kenya as well. So we see a lot of learning from the German example. We see a lot of learning from the right to be forgotten. Right to be forgotten is expanding, particularly in Latin America. So, you know, we are seeing some of that happen in different places around the world. But I do think that, you know, this profound thinking is coming. I would say Germany and the Netherlands have a lot of people thinking very clearly about this.
Yeah, and I think NetzDG has already resulted in penalties and fines on Facebook or Google, either one of them, which I think was a positive kind of move forward. I had a question on Article 19, a gotcha question, but you've already addressed it on the kind of paragraph of the law. And so I'm not going to go there, but I do appreciate you addressing it up front. So in a now infamous interview, Mark Zuckerberg was asked why Holocaust denial is not prohibited on Facebook. He responded by saying, and this is not the direct quote, but he said something like, sometimes people get things wrong, and we don't want to penalize people for getting things wrong. It's easy to say that hundreds of years of anti-Semitic conspiracy theories and other forms of hate are just people getting things wrong. But I think it would be accurate to say that lots of online hate is also intentional campaigns of harassment. And I'm wondering, is it possible to really create rules or even standards when getting at the intent of a user is so difficult? And what if everyone is just getting things wrong?
Yeah, it's I like the way you put the question, because because I think that it's not just a question, it's not just a question of whether the platform should allow Holocaust denial or any other, Holocaust denial is one. There's also, different genocide denial. There's Turkey and Armenia. There's the Rwandan genocide. There's all sorts of historic crimes that are subject to denialism. I mean, I would take it to another level too, and it's also in the context of science. There's a lot of science denialism out there, and so Zuckerberg's point that people should be allowed to get it wrong, I think, assumes that his platform is a kind of clean space where, and this goes back to your point about so many of the platforms having this kind of American DNA. I think of the platforms being marinated in the First Amendment, and they have this idea, and I think Zuckerberg has this idea. It's almost like an or poorly considered idea that the platform is somehow a marketplace of ideas, and the bad ideas are going to wash away. There'll be, the marketplace of ideas goes back to Oliver Wendell Holmes and Justice Brandeis and different theories of speech at the beginning of the 20th century in the United States. And, the truth is these platforms are not clean marketplaces of ideas. They're subject to manipulation. They're subject to real bad actors. I think much of, the Holocaust denialism isn't just, it's not like some academic who says, 5.8 million Jews were killed rather than 6. I mean, that's not what we're talking about. We're talking about people who are denying kind of a fundamental historical fact, and they're often, I would say usually, I mean, I'm not a scholar of this, so so take it with a grain of salt, but very often the intent behind it is actually an intention that is anti-Semitic. And so, and I think this is true for other denialisms as well. And I think, most of the rules of the platforms, for most of their lives, most of the lives of the platforms, most of their history, has assumed it's a marketplace of ideas when it's really not, and the rules need to reflect that. Now, that's a big run-up, and in a way an avoidance of the question, well, what should the rule actually be? Should Holocaust denialism be permitted on the platform, or should the platform take it down? And the problem is, you can have a rule that says Holocaust denialism is not permitted on our platform. I mean, that's permitted by Section 230. It's permitted under, and even encouraged under, European law. The problem is, what is denialism? So it goes back to the issue of, well, what if people are criticizing denialism and that is taken down, which, as you move to a kind of an AI and automated setup, you're going to lose a lot of the content that is informing people about the history of the Holocaust. Now, that might be a totally fair trade-off, but I don't think we can make these decisions and just assume that the answer is, no denialism or denialism. It's not as clean as that, and I don't think it was really careful of Zuckerberg to paint it in that framework. He made a more kind of problematic speech at Georgetown in either November or December, where he kind of doubled down on the idea of the platform as being a kind of free speech nirvana. And I think that just purposefully or not, it misconstrues what the platforms are all about today.
Yeah, and with context being so key to elements like this, moving towards artificial intelligence content review and moderation really complicates the matter, because so much of, and you're right, that it isn't binary, it isn't denialism, non-denialism. There's this entire world in between, which is essentially kind of like dog whistles and like people trying to say something without actually saying it straight up. And I can't imagine artificial intelligence being able to address that. I mean, I know even content reviewers are struggling with dog whistle techniques that hateful users are using in campaign harassment. So it's pretty scary. I want to move to questions that we're getting in the chat. So Fred Nugent has a question of ICCPR. Fred, if you're still there, ask the question.
Here we go. Hi, thanks for being here. I wanted to ask about Article 19.2. You said that it's robust, and that took me aback because we've seen the US government come up with clever ways to get around laws like the Geneva Conventions. We have enemy combatants now, which I think is quite outside the scope of what was a notion of for the Geneva Conventions. And similarly, the NSA has a clever notion of the word collect and what it means to collect things and respect privacy. How is it that international law in general and those things in particular can be protected? Is there some kind of international case law which will shore up interpretations from sort of the governments just deciding not to respect the previous interpretations?
Yeah, so it's a great question. I mean, it allows me to say something about the US first. So the first thing is the United States, probably in a fuller way than most states, tends to ignore international human rights treaties. I mean, your question kind of gets to that a little bit. We've tended as a country to see human rights treaties as the standard that other people should observe rather than necessarily the standard that should guide our own policies. So, and that's historic. That's, Republican and Democratic. It's decades long. It goes back to, kind of it's a century old story, to be honest. And so your question is getting at a real problem. What's interesting though is that, when it comes to Article 19, I mean, the United States, so like the enemy combatant issue I think that is really much more of a Geneva Convention issue than an ICCPR issue, which we can talk about. I used to do work on that, and it's very different, although it shares the basic DNA of, kind of changing language for the purposes of, of where you are at a given moment. But basically, the United States has been pretty supportive of freedom of expression under Article 19. It's been really problematic in the area that you mentioned, which is surveillance, and in particular, the NSA surveillance and what, NSA likes to talk about as bulk collection, which I think we can all think of as mass surveillance. And you kind of have two tracks. So first of all, there's another provision of the ICCPR, Article 17, which protects everyone's privacy against arbitrary or unlawful interference. And there has actually been quite a bit of law that has developed around Article 17, at least in the human rights mechanisms of the UN, and in courts around the world, that make clear that even if there's some version of mass surveillance that is lawful, it needs to be transparent. It needs to be subject to basic rule of law standards. It needs to be subject to standards that allow those who are subject to it to complain and to hold government accountable. And that's been happening, and the US has largely ignored it. But the law has been developing, and I think it's really important as a matter of human rights law for us to separate out two things. One is the development of the law and its general adherence by most governments around the world, and on the other hand, the refusal of some of the biggest governments to adhere to it. And most of what I do and what activists and academics do in human rights space is try to develop this law try to identify where there's something like case law, and set us up for the time when all states observe it, not just states that don't have the power to ignore it.
Okay, thank you.
Thank you.
Luke has a question. Luke, are you there? Luke? He must.
If he isn't, I find it to be a compelling question. Oh, there he goes.
Sorry about that. My question is about privacy. I work for the San Francisco government doing policies regarding surveillance technology. And I work with departments to kind of make more robust their data privacy policies. And I noticed that people are kind of having increased awareness of like having robust data retention policies. And anecdotally, my friends kind of have more awareness of the importance of privacy as it pertains to using social media platforms. But I'm wondering if you can think of any other strategies to make people care more about privacy, whether it's just like education, or like if it's some sort of mass surveillance event that kind of triggers increased awareness. And then like what steps can we take to make people be more proactive about protecting their privacy online?
Yeah, it's a really hard question. And it's hard because, the big event in many respects was in 2013 when Edward Snowden revealed all of this information about the nature of the surveillance state. And not only the surveillance state, but the way in which private American companies essentially went along with it and enabled the sharing of data. And that should have been, I think it was a pretty big wake-up call. It wasn't a big enough wake-up call to change American law in all of the ways that it needed to change. But I think we need events like that. And I mean, sadly, I would say that we're likely to have that kind of event in the context, or I would say that the money should be on having that kind of an event in the context of coronavirus. And I would say that because there's going to be a very big push for data collection, much of which is completely understandable and legitimate from a public health perspective. I mean, the WHO in its guidance talks about public health surveillance as essential to health interventions. I mean, there's no question about that. The question is going to be when personal information starts to be collected on a kind of a broad scale, and it'll be collected with the support of private companies. What are the data protection rules that will be applicable? And California adopted the California Privacy Act, the CCPA, last year, and that goes some distance in identifying what are the obligations of companies. It's not exactly European privacy law like the GDPR, but it's a pretty solid set of privacy protections. But I think once people start to see their own data, once we start to see cases of individuals and their infection status being leaked out in the public, I think people will start to see, if you could imagine, the AIDS crisis in the 80s and data collection in the 1980s, if we had the tools that we have now, I think we would have seen the same kind of concerns, and that would have led to new law at the municipal level. San Francisco is actually ahead of most cities in having a kind of human rights attitude toward many of these kinds of issues. But I think we'll see something like that, and I imagine, with groups like EFF in San Francisco and other advocates in San Francisco who are going to track this really closely, I can imagine that San Francisco will be ahead of the curve on this.
Nice. So Akhilesh has a really interesting hypothetical question about international law. Can you ask your question?
Hi, David. First of all, thanks for being here today. My question was, like, what is the incentive you see in, all the international countries and companies accepting an international law, or even if we design a law which is not one size fits all, because like there is no hypothetical government, overseeing all of this, and there is so much to reconcile between companies, between countries, and then between companies and countries. The case in point one was like you said, ICCPR paragraph 2 of Article 20, which said that it kind of prohibits hate speech but does not allow states to criminalize that. But the interpretation can differing from a country to country. So how do we incentivize such a law over here?
Yeah, it's a really good question. So I think, like, if you think about where the companies are, what they don't want is to have to implement different rules in every jurisdiction where they operate. That's just inefficient for them. So what is the incentive for them? The incentive is, it's kind of a negative incentive, right? So if they look out and see, we're going to be facing all of these different rules around hate speech, that's going to require us to implement different rules according to the community where we're operating or the jurisdiction where we're operating. That's going to be really costly for them. I mean, I could care less about the costs for them, to be honest, but if you're a company and you're just thinking about incentives, that's going to be a cost for them. And so I think what they need to be, I mean, if we want to think about incentivizing them, a way to think about it might be, and I don't know if it really works, and they've resisted this, is to think, if they have rules that are rooted in human rights standards, say Article 20, paragraph 2, or Article 19.3, and the rules around when restrictions are legitimate, then they can go to governments and say, look, we are on our own initiative deciding that the rules that govern our platforms will be the same rules that obligate you as a matter of human rights law, right? So in other words, we're trying, as a company, we're trying to ensure that we're protecting everybody's rights, and also by doing that, being responsive to the way in which governments also have obligations. If they were to do that, it would enable them, I think, to say to governments, look, this isn't just about our terms of service. This isn't just a money or resource issue for us. This is about us trying to stand in your shoes and to do something that you're already obligated to do. Now, will governments be responsive to that? So far, because the companies haven't done it, it's hard to know. But I've been trying to make this kind of a realpolitik argument to the companies, which is, look, it may be too late, by the way. I mean, governments are moving towards regulation anyway, so they might have missed their chance to do this, which probably would have been around 2015, 2016, at the time of, when Europe was seeing, real, kind of hateful, real incitement to violence in the streets, across Europe and so forth. If the companies would have done this then, they might have been in a better position. So they might have missed the opportunity, but I still think they should try. And to me, that would be the incentive. It's either jurisdiction by jurisdiction rules, or look, here's what we're doing. We're adopting rules that are consistent with your own obligations.
Thank you.
I got this question in an email from a student who couldn't attend today, Melrose Wong. And she writes, given how Twitter, Facebook, etc. have been allowed to create their own rules in the wild west of the internet for so long, do you believe it is possible for these platforms to successfully build bridges and consensus around their disparate content management policies?
Yeah, I mean, that's actually tied to the last question in a way. I mean, but this is a little bit more about the building bridges to users and communities rather than just governments. Yeah. I think they've all been trying, and I think many communities see them trying and are not convinced that it's genuine. And so the question for the companies is going to be, how do we build bridges to users how do we give users and communities a greater sense of ownership of this space? And how do we do it in a way that isn't just this kind of disingenuous, hey, we're here to hear from you, and then we'll go do whatever we want to do? And, you know, I think there are things they can do. I think they can create, you know, councils, jurisdiction by jurisdiction, that provide them with greater insight into the impact of their rules on specific communities, so that even if they have a general, let's hope, human rights set of rules, those can be implemented according to different contexts around the world, which is, you know, human rights is kind of capacious enough to allow that kind of differentiation. But they're not doing that now, or they're doing it in a very limited way. And I think that if they do move in a more kind of focused way to actually involve people in their ownership of the company rules and the rulemaking, I think they do better. Now, Facebook is creating this, you know, Zuckerberg has called it the Facebook Supreme Court, but it's the Facebook Oversight Board. That might be an opportunity to have the hardest questions decided in a framework of interaction with stakeholders, but you know, that sort of remains to be seen because that hasn't been stood up yet.
Yeah, we had Zoe Darming, who's been helping develop the Facebook Oversight Committee in our class a few weeks ago. And she was great in explaining the purpose of it, but couldn't give a date as to when it's going to start. So I understand.
Not to me either.
Yeah. It's an interesting problem. And I've always thought that transparency reports are like this low-hanging fruit that would be easy for social media platforms to use to be able to address that community problem. But even the transparency reports today that we see are just very opaque. I call it opaque transparency because they don't provide a lot of information, especially at the community level. Like, we don't know how different communities are being targeted online through hate and harassment, which makes it impossible to really provide any recommendations or address the problem. We have a question from Wei-Wen Wang. Wei-Wen, are you there?
Yeah, yes. Thank you, Professor David, for the very interesting and informative talk. So my question is more general, like with regard to the COVID-19. So under the current circumstances, as you have mentioned, we are seeing more speech censorship and government control on the internet in many countries. And it seems that many people welcome these temporal changes. So I wonder, do you think these special events will have more like lasting changes or impacts on our future government regulations, platform moderations, or even to the individuals?
That is such a great question. It's a big concern, I think. I mean, it's pretty clear that that the companies are taking on new rules that are really aggressive when it comes to coronavirus. And I think that aggressiveness is widely supported by people and by governments. And that might be totally appropriate for purposes of public health. The sun has come out in Los Angeles, apparently, if you can. So I think those rules, that aggressiveness is not appropriate when it comes to other kinds of speech, you know, around, you know, politics or identity or sexual health, reproductive health. I mean, there's all sorts of issues where there's going to be, and there always is, pressure on the companies to be aggressive in their content moderation, and it's just not going to be appropriate. But I think you're right that that there might be a change in the attitude, not just of the companies, but of users and their expectation of robust content moderation. And I think that's problematic. And I would take it maybe one more step further. And this is, I mean, it's a question that I cannot answer. It's more a question that I pose maybe to myself and to others often, which is, as the rules change online, what will the impact be on our own law, on our own political culture, on the way in which, you know, young people see free speech. You know, we've had, I think both in Europe and the United States, a real commitment to freedom of expression. But as we've seen, there's a lot of, there's a lot of interest in there being greater aggressiveness and restriction on the platforms. And a lot of people believe it should be that way. Will that translate into the way people see freedom of expression more generally? Will that over the long term, have an impact on, law students who become lawyers, who become judges, who become legislators? Will we see some change in the way freedom of expression is understood and kind of legislated in the country, or around the world? I mean, you're asking a very specific question about the platforms, but I think it extends to, to the public sphere as well. It's a good question. Thank you.
Thanks, Wei-Wen. And I think we have time for one more question. So Rahul Nangia has a question. Rahul, are you there?
Yes. Hi. So, okay, I have just a very quick hypothetical question again. Since we have tried like different measures around like curbing hate speech, and like we have a lot of limitations in controlling it. So have we tried like an alternate route where we could like just prevent users from being influenced by it? For instance, like if we could show disclaimers on, like, let's say on YouTube video that the content here might not be authentic, or it might not be accurate, or saying that it's a personal opinion that's being expressed here, like don't be influenced by it. So somehow, like if we can prevent users from being influenced, like could we prevent promoting hatred or violence, like just educating the user rather than like trying to curb the hate speech?
Yeah, that is, that's actually where the companies have tried to go in many respects. I mean, they've tried to say, we don't want to be in a position of just taking down content. We want to be in a position of sharing with users maybe like where that content is coming from. So that's one possibility, which would mean, just to give you an example, let's say there's some, this came up in a very substantial way on WhatsApp, around WhatsApp lynchings in India over the last couple of years. But this was also happening on Facebook and Twitter. And you could imagine giving users the tool to see, okay, where did that information come from? How new is the user? Because we know that, and most of the research shows that kind of new accounts tend to be ones that are more involved in the disinformation or in spreading hatred than long existing accounts. So that might be one possibility. The other possibility is what you're suggesting, which is more a dissemination of knowledge, of verifiable facts. You might see, when you go to any platform these days and you do a search on coronavirus, you'll get what Google calls a knowledge platform, a KP, a knowledge panel, a KP, which is, it will give you the, like, where to go for information about quarantine, where to go for, this, that, and the other kind of information. You can imagine that being more a part of what the platforms do. It's problematic though. It's problematic because first there's a infinite variety of, hate and public health crises and so forth that are problematic. And we can't expect the companies to track all of those down and to have special approaches to each of those. I mean, we can think about, like, what are they in our own society, but, these are global platforms. So they have to think about, like 150 different, national levels. A colleague of mine wrote about, actually about platforms in India and calls it hyper-local. Like, what do you do about those most local, circumstances where the national level doesn't even understand the code words that are at issue? So it's, on the one hand, it's a good idea. On the other hand, it's hard to, to make effective in a, at scale. And then finally, I think there is a broader question about, like, do we want the companies to be shaping what's true and what's not, what's verifiable and what's not? Again, in the context of coronavirus, I think we can all accept there should be direction to people to look at CDC and WHO or to your local public health authority. And that can be geolocated in a way that is relatively easy for people. But for the broad scope of other issues out there, you know, it's really tough to see how the companies can do that and do that well, and do that with democratic accountability.
Okay, thanks for answering that.
Yeah, thanks for the question.
So that was the last question, which is perfect because we just have 2 minutes left to the end of class. Again, I want to thank you for an intellectually rigorous and honest, thought-provoking discussion. Also for your stamina. It's 2 hours can be a lot to speak at a time. So I really appreciate it. And I invite everybody to give a virtual applause wherever they're sitting. For this lecture.
Thanks to everybody. And hopefully next time it'll be in person.
Hopefully.
Everybody stay safe.
All right, you too. Thanks.
Take care.